law matters? Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to understand how to protect yourself, your family, and your business regarding various legal issues. We provide information and resources to help you decide whether or not you actually might want to handle some issues yourself. Perhaps that will be helpful to you. If you do decide to reach out to a lawyer, you'll be better prepared, and so will the professional you contact. Our goal, as always, is to help you achieve the best possible results while saving time and money. As always, we want to welcome David Bizarre from the Bizarre & Associates Law Firm in East Providence, who continues to provide us with information and insights and anecdotes on the various issues that we tackle. So, 'tis the season, actually 'tis the day for snow and ice, which leads to slip and fall accidents. And that can happen at work, at home, at retail stores, at nursing homes, so many different places. So when it does happen, who's at fault? Is someone completely at fault, partially at fault? When do you have to report it? What happens if you don't? Apparently, timing even counts in terms of the actual outcome. There's so many variables here. So we're hoping that this will give you an overview in a very key time as it is. So apparently there are many different things that can happen with what seems to be a slip and fall. You know, I think of maybe someone turns their ankle or something, but obviously there are so many other things, even leading up to a brain injury, and I'm sure people have had those kinds of things happen. So when you think about a slip and fall case, what are the elements of it, and what contributes to them? So give us a little primer there.
Premises liability, slip and fall, they can come in many form or fashion. We're talking today a lot about snow because we're dressed like this because today's a snow day. But a slip and fall could be in a store where there's something that fell, like in a grocery store in one of the aisles and the spill wasn't cleaned up properly, or on stairway where the stairs weren't properly maintained or there's no handrail. They come in, as you said, many different styles or fashions. So what are the elements that go into all of those types of things? Well, the first thing is it's a negligence case. So somebody owes you a duty. And what's the duty that's owed? Well, if it's snow, does somebody owe a duty to clear the snow and properly treat the snow? And what is your role? What are you doing on the premises? Are you at a supermarket or a retail outlet that has a parking lot that they didn't clear properly and you're an invitee? Or are you in someone's house where you're not supposed to be there, you're a trespasser? So those things can have an influence on what the duty that's owed to you is, whether you're reasonably expected to be on the premises, and if you are, what steps need to be taken to protect you. So is there a duty? That's number one. And then did someone breach that duty, not properly maintain the premises, didn't clean up the spill in the grocery store, didn't properly treat the snow and ice, had time to do it and didn't do it?
You raise a very interesting point about did they have time to do it. So I guess we had the weathermen reliably tell us it's going to start at thus and such a time, and you know it's falling through the day and into the early morning hours. What's the reason? I know everything is supposed to be reasonable. What's the reasonable amount of time that you can expect someone who owns the property, whether it's the retail shop, the nursing home, my home, your home, what's reasonable amount of time for you to get it cleared out so that somebody, whether they're delivering a package for Christmas or a holiday or edible arrangement of some sort, foods and goods, what's reasonable?
You know, that's really fact-driven, and every situation might be slightly different. So what is it based on the facts? If you own a store and your store is open and you're inviting people in, then you should try to have all of the snow and ice removed if it's already stopped snowing before the people are expected to be there. If it's still snowing, you're not expected to catch the snowflakes as they come down. You've got some time to be able to do it and treat it, and perhaps all you can do initially is put down the salt or sand or whatever it is that you put down to melt some things to try to keep it from forming ice. But you have time to remove it within a reasonable time after the snow stops. That's fair. If you have a store that's closed, you might have some more time to do it because no one's reasonably expected to be there. So the store's closed, the snow stops, you'd get it done before you're open. I think there's probably some defense for someone who came there. I didn't know it was, well, the lights are off and there's no cars in the parking lot and there are no tracks in it, and you drove in, you probably should be on notice that you probably shouldn't get out because you're not getting into the store. So again, it all really depends on what the facts are and what would, as you said, a reasonable person in the circumstances be expected to do. And if you meet that standard, then you haven't breached your duty.
And should we make a distinction between, if it's a store owner, the customer who's coming in to shop versus the employee who goes in to work? It's still premises, but if it's a contract employee, then is it not really a personal injury, but rather a workers' compensation?
Right.
But same story?
Yeah. So if someone comes, no, it's a different story.
Different story.
Yeah.
Different wrinkle.
If someone is coming to work and they're on the premises and you haven't treated or done anything yet and they fall and get hurt, they don't have a liability case against you or a slip and fall case. If they're your employee, they have a workers' compensation claim. And honestly, even if you did everything you could have done and they still slipped and fall and it happened on your premises and it was during their work time and they were expected to be there, it's a workers' compensation case. Liability is not an issue in a workers' compensation case. The customer who comes in and you did everything you needed to do, and you sort of raised this in the introduction too, weren't careful and didn't have the right shoes on and knew it was dangerous and saw someone fall walking in just before them, but they went in that same thing and fell too, they might have what's called in Rhode Island comparative negligence, and in Massachusetts contributory negligence, which will reduce, or in some cases in Massachusetts, eliminate their right to make a claim.
And when you're thinking about slip and fall, when we're thinking about snow and ice, because that's what's presenting itself in this in preparing for this, I had no occasion to think about this before, but trip and fall, where there was a foreign object, so something they couldn't see, didn't see. There's stump and fall, there's an impediment in the walking surface, there's a step and fall where there's an unexpected failure or hole in the walking surface, maybe some concrete pulled up when you were shoveling, but that just happened. If it just suddenly happened, you couldn't fix it, there's snow all around it, how could you possibly be expected to have been negligent? You'd still have to pay the person who fell, presumably. So how would that play out differently?
All of those different types of falls have all the same analysis as to whether or not there's liability. And the one you mentioned about it just happened and you didn't have time to repair it, well, you do have time, if it's a retail place, to put up a notice, a cone or something that shows that there's a danger. You knew about it, you need to try to do something. So that would be, to me, sort of a failure to warn premises liability case. You know there's a defect because you caused the defect. You didn't have time to fix it, but you had time to put up something to warn other people about the defect. So you should do that. That's another way for a lawyer to now look at a case, analyze it, and say, okay, well, no, I don't have a premises liability on the slip and fall or trip and fall or stub and fall or whatever you called it, because that defect just happened. But I do have a claim because they knew there was a defect and they didn't give a warning to the people who might be walking there that there's a defect. So as a good lawyer, we can always look at something and analyze it and determine whether or not there's a possible case there from different angles.
If you are defending the owner of the property, or say you just are working with someone who is opening a store or whatever, would you say whether it's a store owner or a property owner or a landlord that they should at first look at what the state or the city's laws are? Because as I understand now, some parts of Rhode Island have the requirement that you not only clean your pathway, but part of that street that's accessible to all. How would someone understand that or know that if they didn't have the onus on them and go check that out? Do you advise that right away?
Yeah, you should know that because you're responsible for knowing the law and the rules. Some cities and towns have ordinances that say you have to not only clean your property, but the sidewalk, which you don't own, in front of your property, and if you don't clear it, you're responsible for anyone who gets hurt there. Because every city and town has its own laws, which are called ordinances in the city or town, and if the city or town owns the sidewalk, and they're required to maintain it, and they don't, and someone slips and falls on the sidewalk, the city or town, if you give them proper notice, might be responsible for the injury. But if it's a town that has an ordinance that says the budding property owner is required to remove the snow and ice, you could be liable based on that law if you don't do it.
Okay. What happens when you have owned a property, whether you're the landlord or you're owning a retail store, and you've done what you think is a reasonable thing and maybe time-saving thing? You've contracted with a snow plow removing company.
Yep.
They're on the scene and they're supposed to take care of it, but they did or didn't in the right time. Who's liable now? How does that play out?
Okay. So if I own a building and I have tenants in the building, the first question is who's going to be responsible, the owner or the tenant? And as between the owner and tenant, that liability usually is laid out in the lease. So in the lease it might say the landlord is responsible for maintaining the parking lot and removing snow and ice in the parking lot. The tenant is responsible for the area in front of their building. So now it becomes really a critical fact determination. Where did the slip and fall happen? As between the landlord and tenant. For me, the person who got hurt, I'm suing both of you. I don't know who's responsible. I'm going to sue both of you. Now you added a third component into it. Either the landlord, the tenant, or somebody who is responsible hired another company to remove the snow and ice, and they were negligent. So if I'm the owner of the building and I hired them and you sue me, I'm bringing them into the lawsuit and saying, wait a minute, I hired you to do this, you're responsible, therefore you're responsible to this person who got hurt, you pay it. And if I hire somebody, I always ask them, show me your insurance and make sure that they have coverage so that if they don't do it, I know that we're not just relying on suing them and getting their plow to pay for it, but that they actually have insurance to cover the injury if they were negligent.
Good to know. And if you are the injured person, whether it's at your neighbor's or retail place, what should you do? I know you always advise, make sure you document something. So how does that play out from the time that it happens to the time that they hopefully don't have to see you, but perhaps they do?
So it's a different world. So when I say document what it is that happened, the first thing that comes to mind now, as opposed to when I probably told you that the first time 10 or 15 years ago, was take a picture, because everyone
Yes.
has a phone that has a camera in their pocket.
Sure.
And of course, being older and not even thinking about those things, I never think of that initially, but I will tell you to think about it, because if there is a defect and you fell, I know you may be in pain, you might not have the presence of mind to, but if you can, take a picture of it and say, well, here it is. Now you have it documented. That's the best thing you can do. Of course, if there's an ongoing problem, you talk about someone who lives somewhere and they keep complaining to the owner about this problem, fix the problem, fix the problem. That's going to cut both ways on that type of situation, because you know about the problem and you should be able to trying to avoid it if you can. But it's also, if you document it, at least that you contacted the landlord and said, fix the problem, and here's the email, here's the letter, whatever it is that you did, however you contacted them. It's good to have notes and evidence of what you've done to give them notice of the problem.
So if you slip and fall on your way to, I don't know, delivering some mail that you shouldn't have gotten, it should have gone to your neighbor, and you slip and fall then. He's not home, she's not home. You know that you may be able to take a picture, but you also know that you need to be checked out. Ring the doorbell, leave them a note. What would you advise someone to do? Obviously, you need to have some medical attention. Maybe nothing happened. Maybe you're going to be bruised and hurt tomorrow. Maybe you're losing work. I don't know how that goes. It depends on the situation. But what do you advise that someone do when they've been in that situation?
Well, it depends on the situation. If you're really badly hurt, the first thing you're probably going to do with your phone is not take a picture of what caused the problem, but dial 911 and get somebody there to help you. And if your neighbor's home and you can get to the door, you might want to do that if you can, or call them from your phone if you have their phone number and let them know what happened. But yeah, I would want to give them notice for two reasons. Number one, so they know that you got hurt. And number two, so they have an opportunity, if they haven't remedied the situation, to do that. As lawyers, we always look at different ways of finding evidence and information. And one time, I just will give you an example. They called, someone fell, they got hurt pretty badly. They had to call 911, rescue, fire comes. And in the report, from the rescue report, it said that they had trouble getting the person because they were slipping on the ice that had formed where the guy fell. So obviously that was helpful to show that the ice was there. And of course we needed to prove that it was there long enough for the owner of the property to have had time to treat it and put sand down, which I believe in my report said that the fire department had to do that so that they could get the guy to get him to the hospital.
I imagine that there's not always an occasion when you're going to have a witness. I know you always say, look around, seeing if there is one. If it's your neighbor, maybe there's someone else out walking the dog at the time, but probably that's not something. But at least in this case, if someone's coming to pick you up as at an ambulance, then they certainly can attest to the fact that there's a hole here, ice there, or whatever. Inevitably, someone's going to say, it happened on your property. Well, I don't, just call my insurance company. How does that play out, and what do you suggest in that case? Should I call your insurance company?
Well, I would probably say talk to your lawyer first, call a lawyer. Well, because the insurance company, first thing they're going to say to you is, well, we want to take a recorded statement. And I'm not saying that they're going to lead you down a path that they might lead you down, but they might have you starting to say things that aren't exactly the way they happen, and you might be mischaracterizing it in a way that doesn't help your case but helps them. So I would say talk to an attorney, and the attorney will tell you whether or not you're going to give a statement, if you need to give a statement. And if you do give a statement, make sure that you don't say things that aren't accurate or correct. Not that you're going to lie, you're always going to tell the truth, but that you've got to understand what the important things are that you need to tell them that you might not even tell them when you give the statement.
So if someone enlists you or calls you first, would you then bypass or have the bypass going to an insurance? Would you end up then talking to the insurance and not that person?
Correct. Yeah.
So that just shuts that off forever.
Yes.
I can envision some insurance company asking questions. So did you have those shoes, laces? I'm being facetious, but I don't know what other questions that might not be germane. They might be, but I can see someone who will say, I don't know if I did. Did my rubber on my sole, whatever they're going to say. I could see someone stumbling through that, not being prepared. So is that another good reason for someone not to talk to the insurance person
There's a lot of
directly?
good reasons not to talk to the insurance company. And again, any good lawyer will tell their clients, when we're going to give a statement, we're going to tell the truth. But you have to tell the truth because it's perjury otherwise.
Certainly.
But you're going to tell the truth. But you also need to know what are the elements of the slip and fall case that they need to know about that you have to tell them. So, for example, we'll make up a hypothetical, but the person is walking in an area, let's say it's at a store outside, and it had never been treated. And how do you know it had never been treated? Well, there was no sand around it. There was no shoveling around it. There were footprints in it, so it had been there long enough that they had time to treat it. So those aren't things that you might necessarily think about telling the insurance company as you're giving the statement. And then when they have a case, as the case proceeds, it gets to court and so forth, they might say, well, you never said this, did you? Well, you didn't ask that. Well, but you didn't say this, that, the other thing. So there are things that, it's not as much as what you might say, it's as much about what you might not say. So I don't ever recommend giving a statement without having spoken to an attorney first.
So when you're talking to the person who is injured and say you're going to represent them, would you go through that line of questioning that would help determine, I guess, in one way, whether or not it's worth it for you to get involved, maybe, but also whether or not they did have something wrong with their shoe, or whether they were inebriated when they were walking, or there were some other extenuating circumstances? Would you go through that checklist first to help you prepare a case, or to help you school your client or screen your client about comparative negligence? And that's
we want to know everything that happened all of the details, all of the facts, good or bad, because if there are bad facts, we want to know them because we have to deal with them. We're not going to hide them, but we want to know what they are and have a way of dealing with them and not be surprised by them. The last thing you want is to be on, the first day of trial and your client's testifying, and all of a sudden there are facts coming out that you didn't know. That's shame on you. You should know everything before you get there. So yes, you go through everything, and it'll do two things. Number one, it'll help you prepare for the case if you take the case, but it'll also help you decide whether it's a case you want to take in the first place.
And if there is enough reason for you to hear from the client that they really were in all of those things, inebriated, went out barefoot, I don't know what those circumstances might be, but in other words, there is enough going on that says they clearly should bear some responsibility here. Would you at that point say work with the insurance company yourself, or this isn't really worth a case, you have too much responsibility? How does that work, David?
Yeah, well, if it's a case you're not going to take, then you need to let the client know immediately, as soon as you know, so that they know that they either can go look for another attorney, handle it themselves, or do whatever they want with the case, but that you're not going to be responsible for the case for them, because there's always a statute of limitations, and it depends what state you're in. Personal injury, generally, Rhode Island, Mass. is 3 years, so that if it's 2 years and 11 months, and they got 30 days to file suit, and they've just come to you that the last minute, you want them to know, sorry, not taking the case, and by the way, you have 30 days to file suit. Or if you are going to take the case, you need to know you have to file a case within 30 days. But you want to know all the facts and determine. So for instance, let's say a client went to a concert and fell, and they broke their leg, but they didn't realize it was broken at the time. It hurt a lot, but it was a concert. They wanted to stay, had a few drinks afterwards. Then they go to the hospital, and now they do actually have a broken leg. And by the way, they had their blood tests taken, and there's some alcohol in their system. Well, there's alcohol in your system. Yeah, but I didn't drink until after I fell. That had nothing to do with it. Well, okay, that's something you want to know, and you can deal with that. So all of the facts, whatever it might be, you want to be able to bring out.
So how would you deal with that if that were the issue? Would you bring that out rather than have to defend it later?
Yeah.
You'd present that first?
I want to be proactive with everything. And so if I'm at trial, I certainly want to be the one to bring it out. I want a juror to know that I'm not hiding anything. So here it is. Oh, if I was trying it and I wasn't like that, I think the worst thing would be my client's testifying, yeah, broke my leg, did you have anything to drink before you broke? No. And then they come, well, look at this, you had alcohol. And you say, oh yeah, well, that was after. Well, that doesn't seem to play as well to me as just tell the truth right from the front and get it out and be the one to bring it out and say to the juror, yep, I stayed at the concert. Oh my God, my leg was in so much pain, but I had never seen that group before, and I really wanted to see them, and I stayed, and this is, it's probably not a great idea because of the pain I was in, so I had a few drinks to try to numb the pain a little bit, and no, after the concert, my husband took me to the emergency room, and lo and behold, I had a broken leg, and yep, had some alcohol in my system, but it was after. Well, how can you prove it was after? Well, you know what? There are actually cameras at the concert. Should we get copies of that video and show the fact that there was nothing in my hand and that my husband brought me 2 drinks afterwards? Let's get that video and show it.
You raise, in raising those points, that certainly is something that would suggest that you wouldn't want to have a conversation with an insurer first, because insurance agency first, because I'm sure that might come out in a very different way, or even, yes, it would come out in a very different way and then be presented in a different way as well. You always talk about timeliness. It does matter when you report something. In preparing for this segment, it was very interesting to read where Massachusetts Appeals Court declined to apply an exception to a 30-day notice requirement in a recent slip and fall case, and essentially someone ended up having an injury, and when they went to the city and said, I fell, and it happened, and I don't know who else is to blame. It took longer. It took 90 days before they found out that it was Boston Gas, and then that time had already passed. And the court said, well, here's an occasion where the law really isn't working in their behalf. The statute of limitations had already passed. They dismissed the case. But that poor injured person had no way of knowing who the ultimate what
responsible
party would be because it was too far down the line. What happens in that case? I'm sure that while this is one quick little example, I'm sure that there are others like that. What happens in that case when it's more complicated? We can't know who caused that predicament.
Especially when you fall somewhere where you're not 100% sure who the owner of the property is or who might be responsible. And so that's one of the reasons you really need to get to an attorney really quickly, because there are a number of notice requirements. Cities and towns, if you fall on a street or a sidewalk, and it's the city's responsibility for maintaining that area, there's a time frame where you have to give notice. That time frame, you're right, it's pretty much black letter, law. It's got to do it within that time frame. There are some exceptions, like if you're in the hospital in a coma for the 30 days, obviously that might be an exception for something like that. But pretty much count on you have to give notice within that time frame, and there aren't really exceptions to it. Whether you knew who owned it or not, you're supposed to find out right away.
I wouldn't want to say that the city would be dragging its feet. Let's say it didn't. Maybe it just took that long to discover. But if you were working with a client in that kind of situation, and let's not say Boston Gas was dragging its feet before it claimed responsibility, but what can you do? It's clear. Here's the parameter. Here's the date and the time frame, and you can't get at it. Then what do you do? What could you possibly do? You're the lawyer. What could you do? Mary couldn't do something, but you could.
Well,
maybe?
Yeah, if you have an idea and not 100% sure, I would send notice to everybody who could possibly be responsible that is entitled to get notice. And if I'm wrong, I'm wrong, but I guess what harm did I do? As long as I protected my client's rights by sending the notice within the right time frame. So usually it's not quite that difficult to figure it out, but I would send out notice.
So if it weren't that difficult to find out, why wouldn't something have taken place to show that this is a work in progress? The claim's been filed. It may take some time to vet this and check that camera or whatever. But how could that linger that period of time so as to make the next step moot? How could someone drag their feet that long? I mean, let's assume it wasn't intentional.
Yeah, that's why I'm saying if a lawyer has a suspicion that the city owns the property, you need to send notice to the city, and there's a specific things that need to go into that letter. So the location, a lot of times lawyers I've seen have sent notice with sort of like a Google map, specific location of where it is, and all sorts of other information. So I send as much information as I can, and it sometimes turns out, most times it turns out the city is responsible, and so we've sent notice in time. Sometimes it turns out, no, they have an agreement with the abutting landowner or somebody else is responsible. It's not them, but they'll have to give us that information. And of course, we've protected the client, even if ultimately the city in that instance might not have been responsible.
Good to know. Clearly, I can't imagine that this poor unsuspecting person would have second-guessed that there would be that kind of lag time and that kind of consequence. So we often say that it's worthwhile for you to check and help. Maybe there are some things you can do yourself, but clearly in these cases, it's probably worthwhile to not go it alone. We hope that this has been helpful to you. We hope that you don't slip and fall. Stay safe. Pay attention to the law matters. It matters to you. Thank you for tuning in.